Chapter 24, Employment and Discrimination Law, Part 1, presented by Kelly Herzik. Chapter 24 is a fairly long chapter, so I've broken it up into two parts. In this part, Part 1, we will cover at-will employees, federal employment discrimination laws, the Civil Rights Act, specifically Title VII, discrimination based on sexual orientation, discrimination based on marriage, the Age Discrimination in Employment Act of 1967, the Americans with Disabilities Act, discrimination against tobacco users, and the Equal Pay Act of 1963. First, we will discuss at-will employees. In our country's history, in the 18th and 19th centuries, workers had no protections in the workplace under the law. They were at-will employees, meaning they could be fired for any reason, even being injured on the job. In the mid-20th century, employment laws began to change to provide more protections to workers. Today, an employee who is not an employee under an employment contract or not protected by a collective bargaining agreement is still considered an at-will employee. This means the employee may quit for any or no reason with no notice required to the employer. Similarly, the employer can fire the employee for no reason and with no notice, but may not do so for an illegal reason. That's the big change, because there are now laws that protect workers, and any termination based on a violation of state or federal law is considered an illegal reason for termination. There are also exceptions to the at-will employment through breaches of implied contracts based on employment handbook terms. All 50 states and the District of Columbia are still at-will employment states in 2020, though most states have some exceptions to the at-will doctrine. Next, we will discuss federal employment discrimination laws. Today, employees are protected in the workplace by a number of both state and federal laws. Federal laws apply to everyone in the U.S. due to the Supremacy Clause in Article 6 of the U.S. Constitution. We've studied that in constitutional law. However, states and local governments are free to regulate an area of the law as long as those laws do not conflict with federal law or as long as the federal law does not preempt state law. Remember, there are certain areas of the law where the federal government has decided to completely occupy the field of regulation to the exclusion of the states, meaning the federal government is exclusively regulating that area of the law. That's federal preemption. You should remember that doctrine. However, it doesn't really apply in the employment discrimination law area. Most often, federal, state, and even local governments have concurrent authority to regulate various legal areas like employment law. This means that state and local governments are free to pass employment laws and regulate this area as long as compliance with such laws does not force a person to violate the federal Constitution. In the area of employment law, the federal government does not exclusively occupy the field of regulation, and there's plenty of room for state employment laws, and you will see that there is a two-tiered system of federal and state employment laws. Federal law generally provides the floor. Remember, it's the minimum level of protection for all workers. States can provide more but not less protection than federal law, and often does, particularly in the employment law area. In this lesson, we're going to be covering 5 major federal discrimination laws. In this one-page chart, I've given you a summary of each piece of legislation. The first is the Civil Rights Act of 1964. It was amended in 1991. Employment law is governed by Title VII. It protects employees against discrimination and harassment based on race, color, religion, national origin, and sex. Then there is the Pregnancy Discrimination Act of 1987. It amends Title VII sex discrimination to include pregnancy. The next one is the Age Discrimination in Employment Act of 1967. It prohibits age discrimination for employees who are age 40 or higher in the workplace, including hiring and firing decisions. Then there is the Americans with Disabilities Act of 1990. It was amended in 2008. It prohibits discrimination due to disability in the workplace, including job applicants. The final piece of legislation we're going to discuss in this lesson is the Equal Pay Act of 1963. It prohibits employers from paying workers of equal skill, effort, and responsibility differently based on gender. We will begin our discussion of the major employment discrimination laws with the Civil Rights Act of 1964, specifically Title VII. The Civil Rights Act of 1964, sometimes abbreviated the CRA, is divided into sections called titles. Title VII of the CRA deals with discrimination in employment, though Title IX of the Education Amendments of 1972 provides protection against sex discrimination in the context of tenure in universities. It prohibits employers from hiring, firing, or otherwise discriminating in the terms or conditions of employment based on race, color, religion, national origin, or sex. It prevents employers from segregating employees in a manner that would affect their employment opportunities, again, based on race, color, religion, national origin, or sex. Title VII applies to employers who have 15 employees or more for 20 consecutive weeks within 1 year and who are engaged in a business that affects commerce. Congress passed the Civil Rights Act of 1964 based on Commerce Clause authority. The definition of employer includes any federal, state, or local government or agency, any corporation owned by the government like the FDIC, the District of Columbia, Native American tribes, private clubs, unions, most private companies, and employment agencies. The Civil Rights Act of 1964 is truly a landmark civil rights and labor law that prohibits discrimination based on race, color, religion, national origin, or sex. It prohibits unequal application of voter registration requirements and prohibits segregation in schools, employment, and public accommodations. The Equal Employment Opportunity Commission, abbreviated the EEOC, is the federal agency that administers and enforces civil rights laws against workplace discrimination. Kansas also has a state employment anti-discrimination agency called the Kansas Human Rights Commission. Next, I want to walk you through filing a Title VII discrimination claim. It's pretty much the same for all discrimination cases, though I will note any differences based on the law. It's not as simple as just filing a lawsuit in federal court. If an employee wants to file a lawsuit against their employer for discrimination in violation of federal law, generally the employee must first file a charge of discrimination with the EEOC or state equivalent within 180 days from the date of discrimination. After a charge is received, the EEOC has 10 days to give notice to the employer, who then has an opportunity to answer the complaint. The EEOC will investigate and also conduct conciliation negotiations. That's just settlement talks. The EEOC may file a lawsuit on the employee's behalf after it investigates and makes a finding that there is reasonable cause to believe that discrimination has occurred and is unable to resolve the matter through conciliation. The EEOC may also elect not to sue directly. Sometimes it's just a matter of resources or the strength of a case. Once the EEOC closes its investigation, it will give an employee a notice of right to sue letter. Once an employee receives the notice of right to sue letter, the employee has 90 days to file suit in federal or state court, and if the employee fails to file suit within the 90 days, he or she can be precluded from proceeding with the lawsuit. In Kansas, usually the EEOC complaint is handled by the Kansas Human Rights Commission. It's considered a dual human rights EEOC complaint process. An employee does not have to file the complaint with both the EEOC and the state agency. It will automatically be dual processed if filed with the state. So in Kansas, most people file with the Human Rights Commission for that dual process. There are exceptions to the requirement to file a complaint with the EEOC as a condition precedent to a discrimination lawsuit. If an employee wants to file an action based on discrimination under the Equal Pay Act, which we will discuss later, the employee does not need to file a charge with the EEOC first. For age discrimination complaints, which we will also discuss, the employee will need to file a charge with the EEOC, but does not need to wait for the EEOC to complete its investigation. Of course, an employee can always request a right to sue letter from the EEOC before its investigation is complete. Now that we've discussed the EEOC process and how claims are processed there, I want to discuss how a plaintiff who's received their notice of right to sue letter might prove up their discrimination case in court. We will begin with disparate treatment discrimination under Title VII. There are two ways to prove discrimination under Title VII: disparate treatment and disparate impact. So we'll start with disparate treatment. To sue for disparate treatment under Title VII, the plaintiff must be a member of a protected class listed in the Civil Rights Act, which is race, color, religion, national origin, or sex or gender. If an employee in a protected class has been refused work, fired, denied a promotion, or otherwise discriminated against or retaliated against for filing a complaint by an employer in an employment action based on their status in a protected class, this is a form of intentional or deliberate discrimination. When the employee sues for disparate treatment discrimination, proving this type of discrimination under Title VII is a three-step process. First, the plaintiff must demonstrate a prima facie case of discrimination. Then the burden shifts to the defendant to articulate a legitimate, non-discriminatory business reason for the action. If they do so, then the burden shifts back to the plaintiff, who must prove that the reason given by the defendant is a mere pretext. This three-part test for disparate treatment was articulated in the 1973 U.S. Supreme Court case of McDonnell Douglas versus Green. If the case proceeds to court with the employee as the plaintiff, or the EEOC as the plaintiff if it brings the lawsuit itself, the case will go through regular court procedures. I've already discussed that in previous lessons, and I won't repeat the court procedures necessary here. If the case is tried, it will be the fact finder, either a jury or a judge sitting in the bench trial, who will decide if discrimination has occurred. Since this is a civil action, the plaintiff has the burden of proof by a preponderance of the evidence. If the plaintiff is successful, damages can be awarded under Title VII for intentional discrimination, which include up to 2 years of back pay, back benefits, compensatory damages like pain and suffering. Those are only available for intentional cases under Title VII and intentional cases under the ADA. Then there are punitive damages, again, only available for intentional cases under Title VII and intentional cases under the ADA. Attorney's fees, court costs, and equitable relief, such as reinstatement and remedial seniority, are also available. Whenever discrimination is found, the goal of the law is to put the victim of discrimination in the same position, or nearly the same, that he or she would have been in if the discrimination had never occurred. The types of relief will depend upon the discriminatory action and the effect it had on the victim. Now remember that compensatory damages pay victims for out-of-pocket expenses caused by the discrimination, such as costs associated with a job search or medical expenses, and compensate them for any emotional harm suffered, such as mental anguish, inconvenience, or loss of enjoyment of life. Punitive damages may be awarded to punish an employer who has committed especially reckless or malicious acts of discrimination. Front pay may also be given in lieu of being hired or rehired if it's not practical to put the employee back in the position. Front pay is money awarded for lost compensation during the period between judgment and reinstatement back into the position, or in lieu of reinstatement, which it most often has, and is awarded based on a court's discretion, usually for a set period of time. Front pay is just a lump sum of money, usually given for a term of months. Employers who adopt anti-discrimination policies, effectively enforce it, and thoroughly document the policy's strict enforcement may use the policies as a good faith defense against punitive damage awards only. Next, we will discuss damage caps for Title VII intentional discrimination cases. As a result of the Civil Rights Act of 1991, In addition to back pay, attorney's fees, court costs, and other out-of-pocket expenses, employees who win an ADA or Title VII intentional discrimination case can ask the court to award compensatory damages for their pain and suffering and punitive damages. However, the amount of damages that can be awarded depends on the size of the employer. These limits are for the combined total of compensatory damages for pain and suffering and punitive damages taken together. The court can award up to $50,000 if the employer has 15 to 100 employees. The court can award up to $100,000 if the employer has 101 to 200 employees. The court can award up to $200,000 if the employer has 201 to 500 employees. And for larger employees with more than 500 employees, the court can award up to $300,000. That's the most that you can get. Punitive damages are not available against a government entity or political subdivision, so you can only get punitive damages against a private entity. Now that we've discussed proving up intentional discrimination cases through disparate treatment cases, we will discuss disparate impact discrimination under Title VII. Disparate impact discrimination cases are sometimes called unintentional discrimination cases. While a disparate treatment case, an intentional case, is hard to prove, disparate impact cases are even harder to prove. As a defense attorney, I have never lost a disparate impact case. Disparate impact cases occur when a plaintiff attempts to establish that an employer's policy or practice, while neutral on its face, one that appears to apply to every employee equally, actually disproportionately affects or limits employment opportunities for a protected class. You have to have an expert, and a good one, if you're a plaintiff in this area. The plaintiff's case goes through the EEOC process just like the intentional cases. If the plaintiff gets a notice of right to sue letter, either because they didn't prove up their case at the EEOC or because the EEOC has decided not to prosecute the case directly, then the plaintiff can file suit in federal or state court. In disparate impact cases, the plaintiff has the burden to prove statistically that the employer's policy disproportionately impacts a protected class of which they are a member. Remember, as I said, a plaintiff has to have a good expert in this area, and so does the defense for that matter, and it has to be someone who understands and has a background in statistics. Once the plaintiff statistically proves his or her case, the burden then shifts to the defendant employer, who can avoid liability by showing that the practice or policy is a business necessity. The burden then shifts back to the plaintiff, who can still recover if he or she proves the claimed business necessity is a pretext for discrimination, or that there was a less discriminatory policy or practice available but the employer failed to use it. If the plaintiff wins a disparate impact case, they can recover back pay, attorney's fees, and costs, but they can't recover compensatory damages, including pain and suffering, or punitive damages. Those are not available in unintentional cases. A plaintiff can get equitable relief, such as being put in the position denied, reinstated to a position, or given retroactive seniority. Let's look at an example. Suppose an employer requires a high school diploma for all positions. Now, requiring a high school diploma for employees does not seem on its face discriminatory. However, it may statistically impact a protected class disproportionately in employment or promotion opportunities. The next topic we're going to cover is sexual harassment under Title VII. Harassment is not explicitly in Title VII. The word harassment doesn't actually appear. But the Supreme Court, in a unanimous decision in 1986, recognized that sexual harassment can be actionable under Title VII in Meritor Savings Bank versus Vinson. Harassment first developed in the context of discrimination based on sex and evolved to become applicable to other protected classes like harassment based on religion or harassment based on race. Sexual harassment has been defined by the EEOC and approved in Supreme Court precedent as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature that implicitly or explicitly makes submission to the sexual conduct a term or condition of employment, makes employment decisions related to the individual dependent on submission to or rejection of such conduct, or has the purpose or effect of creating an intimidating, hostile, or offensive work environment. There are two types of sexual harassment recognized under the law. Quid pro quo sexual harassment, meaning the demanded sexual conduct is a term or condition of employment. At its most basic, it is have sex with me or I'll fire you. Or there can also be a hostile work environment. Harassment does not have to be of a sexual nature specifically, however, and can include offensive remarks about a person's sex. For example, it is illegal to harass a woman by making offensive comments about women in general. Both the victim and the harasser can either be a woman or a man, and the victim and harasser can be of the same sex. Although the law doesn't prohibit simple teasing, offhanded comments, or isolated incidents that are not very serious, harassment is illegal when it is so frequent, so pervasive, or severe that it creates an abusive, hostile, or offensive work environment, or when it results in an adverse employment decision, such as the victim being fired or demoted. The harasser can be the victim's supervisor, a supervisor in another area, a coworker, or someone who is not an employee of the employer, such as a client or a customer. Generally, sexual harassment is in the eye of the beholder. It's determined from the standpoint of the plaintiff, though there is an objective element as well to protect against unduly sensitive plaintiffs. Though courts have articulated several tests, in general, hostile work environment plaintiffs must prove that he or she belongs to a protected class under Title VII, that the conduct was unwelcome, that the conduct was based on the plaintiff's protected category, that the plaintiff subjectively viewed the conduct as creating a hostile work environment, that's the eye of the beholder prong, and that a reasonable person would also objectively view the work environment as abusive, that's the objective prong. Now, hostile work environment claims generally have a pretty high bar. Courts look to see if the conduct is both pervasive and severe. Listen to this list of things that have been found to create a hostile work environment, and you'll understand why the bar is so high. Rape, repeated offensive touching of intimate body parts, physical threats at work, repeated solicitation for sex, and or daily or repeated verbal harassment have all been found to constitute sexual harassment sufficient to create a hostile work environment. That's a pretty high bar if that's the conduct you have to prove to get to sexual harassment and hostile work environment. In addition, companies are not automatically vicariously liable for hostile work environment claims, and there are affirmative defenses available. We'll discuss those later. In quid pro quo cases, a plaintiff generally has to show that a supervisor took a tangible adverse employment action. They actually did something, such as demotion, refusing to promote, or even firing, due to the employee refusing sexual demands, or that the employee's submission to the unwelcome advances was an express or implied condition for receiving job benefits. The plaintiff does not need to prove hostile work environment in quid pro quo claims. That means they don't have to produce 4 and 5 up above. Damages are the same as for other intentional discrimination cases. Employers generally are strictly liable for a supervisor's action in quid pro quo cases. I want to point out that hostile environment case law precedent has also been used in cases of discrimination based on religion and race to establish a hostile work environment. An employment policy or practice that applies to everyone, regardless of sex, can still be illegal if it has a negative impact on the employment of people of a certain sex and is not job-related or necessary to the operation of the business, meaning it is also possible to have a disparate impact claim based on sex discrimination. The next major piece of legislation in the employment discrimination law area is the Pregnancy Discrimination Act of 1987. The Pregnancy Discrimination Act of 1987 amended Title VII. It expanded the definition of discrimination based on gender to include discrimination based on pregnancy. It includes discrimination on the basis of pregnancy, childbirth, or related medical conditions, and constitutes unlawful sex discrimination under Title VII. It forbids discrimination based on pregnancy when it comes to any aspect of employment, including hiring, firing, pay, job assignments, promotions, layoff, training, fringe benefits such as leave and health insurance, and any other item or term of condition of employment. Under the Act, any temporary disability caused by pregnancy must be treated the same as any other temporary disability. For example, the employer may have to provide light duty, alternate assignments, disability leave, or unpaid leave to pregnant employees if it does so for other temporarily disabled employees. It is unlawful to harass a woman because of pregnancy, childbirth, or a medical condition related to pregnancy or childbirth. Harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employment decision, such as the victim being fired or demoted. The harasser can be the victim's supervisor, a supervisor in another area, a co-worker, or someone who is not an employee of the employer, such as a client or customer. One of the worst cases I had in this area was at a construction company. There was a woman who worked as an administrative assistant, and every day one of the field workers would come in, say hi to her, and then grab her stomach and call her a hot mama. The supervisor was right there, and he'd laugh. This went on for a while, and for a while she put up with it because she wanted to get along, but eventually she got mad and filed an EEOC claim. Of course she would. We settled that case in conciliation, and afterwards both the supervisor and the employee were fired. Next, we will discuss employer defenses to claims under Title VII. There are several defenses to Title VII claims. The three most common defenses available to the employer defendants are the bona fide occupational qualification, merit, and seniority system defenses. These are defenses available in disparate treatment and disparate impact cases, but not harassment cases. They don't apply there. First, let's talk about the bona fide occupational qualification defense. This allows an employer to discriminate in the hiring on the basis of sex, religion, or national origin, but not race or color, when it is necessary for the performance of the job based on the actual qualifications and not stereotypes. For example, it might be acceptable to hire only females to model female clothing, or to only have a female attendant for a woman's restroom or a male attendant for a men's restroom. Then there is the merit defense. This defense is usually raised when hiring or promotion decisions are based on test scores, based on professionally developed ability tests, and not designed or intended or used to discriminate. Most police officers actually test for like the sergeant's exam or the lieutenant's exam. It's one of the main portions of their promotional systems. In conjunction with the merit defense, many employers rely on the Uniform Guidelines on Employee Selection Procedures. This is a handbook, and it has guided government agencies charged with enforcing civil rights and employers about when job-related ability tests are valid and truly job-related. It's a government treatise, and it's often used. Next, let's talk about the seniority system defense. A bona fide seniority system is a legal defense if the system applies equally to all persons, the seniority unit follows industry practices, the seniority system did not have its genesis in discrimination, and the system is maintained free of any illegal discriminatory purpose. Now let's talk about harassment affirmative defenses. As long as an adverse employment action is not involved, meaning it's not quid pro quo, an employer can defend against harassment hostile work environment claims if the employer took reasonable action to prevent and correct sexual harassment in the workplace and the plaintiff unreasonably failed to take advantage of those corrective or preventative measures. This defense is known as the Faragher-Ellerth defense, based on two Supreme Court cases from 1998 that articulated that defense. For sexual harassment, hostile work environment claims, having a written and detailed sexual harassment policy and an avenue for employees to report harassment can satisfy the first prong of the Faragher-Ellerth defense. Failing to report sexual harassment to HR through the procedures in a written sexual harassment policy might satisfy the second prong. In other words, if the employee doesn't take advantage of the reporting avenues available to them, that can satisfy the second prong of the defense. This defense is generally not available in quid pro quo intentional harassment cases. You need to remember that. Next, we will discuss discrimination based on sexual orientation. No federal legislation or statute currently exists that expressly prohibits discrimination based on sexual orientation or gender identity. There's no federal statute that says no one can discriminate based on sexual orientation or gender identity specifically. However, at the state level, 21 states, Puerto Rico, Guam, and the District of Columbia have all passed laws that prohibit discrimination specifically based on sexual orientation and gender identity. 2 more states have done so through case law and executive order, and 2 additional states prohibit discrimination based on sexual orientation only and do not mention gender identity. 10 states, including Kansas, have an executive order or regulation prohibiting discrimination in public employment only based on sexual orientation or gender identity. That means, for example, state government jobs, there can be no discrimination based on sexual orientation or gender identity. But the executive order or the regulations do not apply to private employers in those states. The EEOC identifies discrimination against an individual because of gender identity, including transgender status, or because of sexual orientation, as discrimination based on sex in violation of Title VII. This means that while there is no express statutory protection at the federal level, the EEOC interprets Title VII's prohibition against sex discrimination to include discrimination based on sexual orientation or gender identity. The EEOC has long seen Title VII's prohibition against sex discrimination as an umbrella that also protects sexual orientation and gender identity. According to the EEOC, Title VII protects lesbian, gay, bisexual, and transgender applicants and employees against employment bias and discrimination. The EEOC, during enforcement actions, has obtained monetary relief for individuals, as well as numerous employer policy changes in voluntary resolutions of LGBT discrimination charges under Title VII. Now, the Trump administration has sought to challenge the EEOC's interpretations of Title VII in the courts. And in fact, this summer, 3 cases made their way up through the appellate courts to the Supreme Court. On June 15, 2020, in a 6-3 decision, the Supreme Court, in a trio of cases consolidated with Bostock versus Clayton County, Georgia, held that discrimination on the basis of sexual orientation and gender identity is covered under the sex discrimination provisions of Title VII of the Civil Rights Act of 1964. The court ruled with the EEOC's interpretation that sex discrimination under Title VII necessarily includes discrimination based on sexual orientation and gender identity. I think it's important to note that the decision involved the statutory interpretation of Title VII, not constitutional law, as in other recent landmark cases involving the rights of LGBT individuals, such as Obergefell versus Hodges, which we will discuss in the next slide. The court further held that Title VII protections against sex discrimination in the employment context apply to discrimination against particular individuals on the basis of sex, as opposed to discrimination against groups. This means that Title VII provides a remedy to individuals who experience discrimination on the basis of sex, even if an employer's policy on the whole does not involve discrimination. Justice Gorsuch, who was appointed by President Trump, wrote the majority opinion and stated that an employer who fired an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. Those who adopted the Civil Rights Act might not have anticipated their work would lead to this particular result, but the limits of the drafter's imagination supply no reason to ignore the law's demands. Only the written word is law, and all persons are entitled to its benefits. It's a powerful sentence. Many large corporations had already voluntarily provided these protections against discrimination to their employees, so Bostock did not require a change to their policies on sex discrimination. Now we will discuss discrimination based on marriage. On June 26, 2015, in a historic 5-4 decision, the U.S. Supreme Court found state law bans on marriage equality to be unconstitutional, and that the right to marriage is a fundamental right for everyone. This is the Obergefell versus Hodges case I mentioned on the previous slide. In Obergefell, the Supreme Court ruled that the fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment to the United States Constitution. Now you contrast Obergefell, which was a constitutional interpretation of the 14th Amendment, with Bostock, which was simply a statutory interpretation of Title VII. I think that's why you see that Bostock is a 6-3 decision, because some of the conservatives were willing to look at the interpretation of a statute as narrower than, say, Obergefell, which was an interpretation of the 14th Amendment. Now, in Obergefell, the majority opinion stated that in interpreting the 14th Amendment's Equal Protection Clause, the court has recognized that new insights and societal understandings can reveal unjustified inequality within the United States' most fundamental institutions that once passed unnoticed and unchallenged. The majority definitely followed the legal realism school of thought, which we talked about in Chapter 2, which allows a court to look beyond the narrow principles of the law to societal interests, economic conditions, and public policies in deciding a case. The Supreme Court in Obergefell struck down Section 2 of the Defense of Marriage Act of 1996, a federal law that provided that no state would be required to give effect to same-sex marriages granted by other states. The 1996 law was designed to give states an exception to the full faith and credit clause of the U.S. Constitution, which provides that the various states must recognize legislative acts, public records, and judicial decisions of other states within the United States, which would normally include a marriage, and which was routinely the case for opposite-sex marriages. Prior to Obergefell, a same-sex couple could marry in a state where the marriage was legally recognized, but if they moved to a state that did not recognize such unions, they were legally treated as if the marriage did not exist. You can imagine the heartache and the upset that that would cause people if they had to transfer for a job, if they had children that they had to explain that suddenly mommy and mommy or daddy and daddy aren't married anymore. Obergefell changed that. The next major piece of legislation that I want to discuss is the Age Discrimination in Employment Act of 1967. The Age Discrimination in Employment Act, the ADEA, of 1967 prohibits employers from refusing to hire, discharging, or discriminating in the terms and conditions of employment on the basis of an employee being age 40 or older. The ADEA language is virtually identical to Title VII, except that it applies to age as the discrimination factor. It applies to employers that have 20 or more employees. An employee who believes he or she has been discriminated against due to age under the AEDA must still file a charge with the EEOC or state agency, but they do not need a notice of right to sue from the EEOC to file suit. They may file a lawsuit in federal court 60 days after the charge was filed with the EEOC. Under the ADEA, employees cannot recover either compensatory or punitive damages, but they may be entitled to what they call liquidated damages, which may be awarded to punish an especially malicious or reckless discriminatory act. The amount of liquidated damages that may be awarded is equal to the amount of back pay awarded to the employee. Next, we will discuss the Americans with Disabilities Act, the ADA. The ADA prohibits discrimination against employees and job applicants with disabilities. The ADA requires employers to make reasonable accommodations for known physical or mental disabilities of an otherwise qualified person with a disability. A reasonable accommodation is any change in the work environment or in the way things are usually done to help a person with a disability apply for a job, perform the duties of a job, or enjoy the benefits and privileges of employment. Reasonable accommodations might include, for example, making the workplace accessible for wheelchair users or providing a reader or interpreter for someone who is blind or hearing impaired. However, the proposed accommodation is not required if it would impose an undue burden on the employer's business. The EEOC also enforces the ADA in the same manner it enforces Title VII. The EEOC also enforces Sections 501 and 505 of the Rehabilitation Act of 1973 concerning persons with disabilities. To succeed in a lawsuit under the ADA, the plaintiff must prove that he or she has a disability, was otherwise qualified for the job, and suffered an adverse employment decision because of that disability. Remedies are similar to Title VII, including compensatory and punitive damages for intentional discrimination. Remember that remedies would include back pay, benefits, injunctive relief, such as an order to provide the accommodation, reinstatement or being placed in the job, costs and attorney's fees, plus compensatory damages and punitive damages, though they are capped at the Title VII rates based on employer size. Next, I want to discuss discrimination against tobacco users. Believe it or not, in the 21st century, the use of tobacco products in the workplace is still an important employment law issue. Many employers do not want to hire or retain employees who are smokers, under the theory that such workers can be more expensive in terms of healthcare costs and they are less productive due to missed work. Whether or not an employer can refuse to hire or fire a smoker depends on state law. There are no federal statutes protecting smokers. Currently, 29 states and the District of Columbia have statutory protection for employees who smoke or use tobacco products. Most of these statutes were passed in the 1980s and 90s, though some are more recent. There are 4 states that do not have specific tobacco use protection statutes, but smokers are protected under broader statutes that prohibit employers from discriminating against any employee who engages in a lawful activity, and smoking is a lawful activity. Kansas has no statute protecting smokers or users of tobacco or other products. The final statute I want to discuss in this lesson is the Equal Pay Act of 1963. The Equal Pay Act, the EPA, of 1963 prohibits employers from paying workers of one gender less than the wages paid to employees of the opposite gender for work that requires equal skill, effort, or responsibility. The EPA was specifically intended to protect women from wage discrimination. In 1963, the average wage for women was less than 60% of those for men. The EPA amended the Fair Labor Standards Act. It requires equal pay for equal work performed under similar working conditions, except when payment is made pursuant to a seniority system, a merit system, or a system which measures earnings by quantity or quality of production, or differentials based on any factor other than sex. These are the exceptions to the general rule. In any lawsuit, the EPA exceptions I just listed are considered affirmative defenses an employer must prove to justify the unequal pay scheme. In practice, the exceptions have swallowed the rule, meaning the EPA has been weakened by loopholes, inadequate remedies, and adverse court rulings, resulting in protection that is far less effective than Congress originally intended. The EPA applies to all aspects of compensation, including salary, overtime pay, bonuses, stock options, profit sharing and bonus plans, life insurance, vacation and holiday pay, cleaning or gasoline allowances, hotel accommodations, reimbursement for travel expenses, and benefits. Anything that can remotely be considered compensation is covered by the Equal Pay Act. If an employer does attempt to equalize pay, no employee's pay may be reduced. Rather, the affected employee's pay must be increased. To sue under the Equal Pay Act, an employee does not need to file a charge with the EEOC first as a condition precedent to sue. This is the only statute regulated by the EEOC which does not require at least a charge being filed prior to a lawsuit. This means if you want to sue under the Equal Pay Act, you can go directly to federal court and you do not have to go to the EEOC or your state equivalent first. Employees must file suit or a charge with the EEOC if they want to within 2 years of the alleged unlawful compensation practices, or in the case of a willful violation within 3 years. Unfortunately, the Equal Pay Act does not provide for compensatory or punitive damages, only liquidated damages equal to the back pay awarded to employees, plus attorney's fees and costs. This is the end of Chapter 24, Part 1.